5 seconds to go. Start. Dictionary Volume 1 is revealing in as much as the import of the word any has been explained from pages 145 to 153 of the 4th edition, a perusal of which shows it has different connotations depending primarily on the subject matter of the statute and the context of its use. A bench of this court in Lucknow Development Authority versus M.K. Gupta 1994 1 SCC 243 gave a very wide meaning to this word, finding place in section 2O of the Consumer Protection Act 1986 defining service. Sri Chidambaram rightly argued that the word any will have to be construed in its context, taking into consideration the scheme and the purpose of the enactment. There can be no quarrel with regard to the said proposition. Right from the judgment of the Constitution Bench of this court, in the case of the Chief Inspector of Mines and another versus Lala Karamchand Thapad etc. Supra, the position is clear. What is the meaning which the legislature intended to give to a particular statutory provision has to be decided by the court on a consideration of the context in which the words appear and in particular the scheme and object of the legislation. We find that for deciding the present issue, it will also be necessary to refer an important principle of interpretation of statutes, that is of purposive interpretation. Legislation has an aim, it seeks to obviate some mischief, to supply an inadequacy, to effect a change of policy, to formulate a plan of government. That aim, that policy is not drawn like nitrogen out of the air, it is evidenced in the language of the statute as read in the light of other external manifestations of purpose. This is how Justice Frankfurter succinctly propounds the principle of purposive interpretation. It is thus necessary to cull out the legislative policy from various factors like the words in the statute, the preamble of the act, the statement of objects and reasons, and in a given case, even the attendant circumstances. After the legislative policy is found, then the words used in the statute must be so interpreted such that it advances the purpose of the statute and does not defeat it. Francis Bennion, in his treatise Statutory Interpretation at page 810, described purposive construction in an equally eloquent manner as under. A purposive construction of an enactment is one which gives effect to the legislative purpose by following the literal meaning of the enactment where that meaning is in accordance with the legislative purpose in this code called a purposive and literal construction, or applying a strained meaning where the literal meaning is not in accordance with the legislative purpose in the code called a purposive and strained construction. A statute must be construed having regard to the legislative intent. It has to be meaningful. A construction which leads to manifest absurdity must not be preferred to a construction which would fulfill the object and purport of the legislative intent. The former president of the Supreme Court of Israel, whose exposition of doctrine of proportionality has found approval by the Constitution Bench of this court in the case of Modern Dental College and Research Center and others, supra, to which we will refer to in the forthcoming paragraphs in his commentary on purposive interpretation in law, has summarized the goal of interpretation in law as under. My answer is this. The goal of interpretation in law is to achieve the objective, in other words, the purpose of law. The role of a system of interpretation in law is to choose from among the semantic options for a given text the meaning that best achieves the purpose of the text. Each legal text, will, contract, statute, and constitution was chosen to achieve a social objective. Achieving this objective, achieving this purpose, is the goal of interpretation. The system of interpretation is the device and the means. It is a tool through which law achieves self-realization. In interpreting a given text, which is, after all, what interpretation in law does. A system of interpretation must guarantee that the purpose of the norm trapped in our terminology, the purpose of the text, will be achieved in the best way. Hence, the requirement that the system of interpretation be a rotational activity. A coin toss will not do. This is also the rationale which is at the core of my own views for the belief that purposive interpretation is the most proper system of interpretation. This system is proper because it guarantees the achievement of the purpose of law. There is social, jurisprudential, hermeneutical, and constitutional support for my claim that the proper criterion for interpretation is the search for law's purpose, and that purposive interpretation best fulfills that criterion. A comparative look at the law supports it as well. I will discuss each element of that support below. The learned judge emphasized that purposive interpretation is the most proper system of interpretation. Stop.